Judge grants Sess's deadline extension on Ripple case, a request made by the United States Securities and Exchange Commission to extend the deadline for filing a response that could bring an end to its action against Ripple Labs has been granted by Judge Analisa Torres of the United States District Court. This is the official document released by the court. The Securities and Exchange Commission, SEC, was granted an extension to file its remedies-related discovery papers from Ripple, according to court documents that were filed on March 1. As a result of the extension, the regulatory body will have until March 22 to submit its opening brief. The deadline for Ripple's opposition brief has also been extended to April 22, and the new date for the SEC to file a reply will be extended to May 6, 2024. Both deadlines have been extended. A briefing that is connected to remedies is a document that describes prospective legal remedies and actions that could be examined or pursued in connection with the investigation or litigation. An extension of the deadline was requested by the SEC. Origin departs in December 2020. The Securities and Exchange Commission initiated legal proceedings against Ripple Labs. The SEC also accused the business, along with its CEO Brad Garlinghouse and co-founder Chris Larson, of engaging in an unregistered securities offering that was worth $1.03 billion. This was accomplished through the sale of the XRP. The Securities and Exchange Commission believes that the token ought to be categorized as a security and hence be subject to stringent regulatory restrictions. However, Ripple maintained that XRP is not a security and that the SEC did not provide it with adequate notice regarding its categorization. Ripple argued that the SEC failed to provide them with fair notice. Over the years, the litigation has been subject to a great deal of development and legal conflict. A key part is a controversy that surrounds the Howey test, which is utilized to establish whether or not a transaction meets the criteria for an investment contract according to the laws of the United States. As far as the SEC is concerned, XRP satisfies the requirements of the Howey test. However, Ripple contends that this is not the case. In July 2023, a significant event occurred when Torres issued a ruling that largely favored Ripple Labs. He determined that XRP was not a security in the context of its programmatic sales on digital asset exchanges. This was a significant milestone. On the other hand, the judge decided that XRP was a security when it was presented to institutional investors for purchase. Ripple has been approached by Cointelegraph, but the publication has not yet received a response. In a remarkable turn of events, the Securities and Exchange Commission, SEC, has submitted a request to Judge Analisa Torres to extend the deadline for filing its opening brief concerning remedies until March 22, 2024. In addition, the time for Ripple to submit its opposition brief has been extended from April 12 to April 22, and the date for the SEC to submit its response has been pushed back between April 29 and May 6 to provide the SEC with additional time to analyze the discovery materials that Ripple has submitted on remedies. The lawsuit has been extended by 1 week. The cryptocurrency known as XRP is extremely sure that the litigation is almost ended despite the possibility of a settlement between Ripple and the SEC. Lawsuit between Ripple Labs and the United States Securities and Exchange Commission in a crucial move in the ongoing dispute between Ripple Labs and the SEC. The judge signed an order relating to the SEC's request to extend deadlines for remedies-related briefing, as well as opposition to briefing and reply. The court's decision regarding the SEC's request to extend the deadline according to a court document. The judge has approved the application of the United States Securities and Exchange Commission to modify the dates for remedies-related briefing, as well as Ripple's resistance to briefing and the SEC's response to Ripple's opposition. It was requested by the Securities and Exchange Commission, that Judge Analisa Torres extend the deadline for filing its opening brief concerning remedies from March 13 to March 22, 2024. Additionally, the time for Ripple to submit its opposition brief has been extended from April 12 to April 22, and the deadline for the SEC to submit its reply has been extended from April 29 to May 6. The action has been prolonged by 1 week, which will provide the SEC with more time to analyze the discovery papers that Ripple has submitted that pertain to remedies. The motion that Ripple made to delay the discovery requirements linked to remedies by 1 week was granted by Magistrate Judge Netburn earlier. These requirements included the submission of detailed financial accounts and the selling of XRP by institutions after the lawsuit was filed. As Ripple and the SEC continue to discuss the possibility of settling, The XRP army is optimistic that the litigation is getting closer and closer to being resolved. In the meantime, the deadline for the Securities and Exchange Commission coincides with the date for the partial shutdown of the United States government, and a bill has been delivered to President Joe Biden to avoid the shutdown. Bitcoin exchange traded funds, ETF saw a net inflow of $1.07 billion last week. And Bloomberg analyst hints a fall the Ripple v. SEC lawsuit is getting closer to its conclusion. As was previously reported by CoinGate, the deadlines have been extended to April, which coincides with the final modifications to the rule that the SC will implement in April 2024 regarding the protection of advising client assets. In response to the points that the SEC presented regarding investment contracts, a lawyer who is in favor of XRP named Bill Morgan stated the significant flaw in the SEC's interpretation of investment contracts as they pertain to crypto assets. It is impossible to find a limiting principle. In addition, he stated that there is no justification for an impossibly intricate and expansive application of the Howey principle simply because an asset class is distinct from any other asset class that has always been. In the previous 24 hours, the price of XRP has increased by more than 8%, and it is currently trading at 63 cents. The low for the past 24 hours is 58 cents, and the high for the same period is 64 cents. The trade volume, on the other hand, has dramatically surged during the past few days amid a general rally in the cryptocurrency market. Judge Annalisa Torres has granted an extension to the Securities and Exchange Commission in its continuing case against Ripple Labs. This is a new development in the ongoing dispute about XRP, one of the most important steps that might potentially bring the high-profile case to a conclusion is the regulator's request for additional time to file its discovery papers relating to remedies. Ripple's chief executive officer, Brad Garlinghouse, and the company's executive chair, Chris Larson, were both accused of wrongdoing by the Securities and Exchange Commission seat. According to a report that was published by the Kleinreis in the previous year, after achieving a partial court victory, the American Payments Company was able to achieve this. To submit its opening brief, the SEC has until March 22. The Securities and Exchange Commission now has until March 22 to submit its opening brief as stated in court records that were submitted on March 1. This extension of the time was allowed by Judge Torres. Additionally, the date for Ripple's opposition brief has been extended until April 22. This comes at the same time. It is anticipated that the SEC will submit a response by the 6th of May, 2024. Thorough document that outlines various legal remedies and actions that may be examined or pursued in connection with the litigation that is currently being discussed is referred to as a remedies-related briefing on the subject. The rivalry between the SEC and Ripple as of December 2020. The Securities and Exchange Commission launched its action against Ripple Labs, stating that the company, together with CEO Brad Garlinghouse and co-founder Chris Larson, was responsible for orchestrating an unregistered securities offering that was worth $1.03 billion through the sale of the XRP cryptocurrency. Ripple is adamant opposed to the idea that XRP should be classified as a security